All right. Hi, everybody. I'm Alan Rippin. I'm the Center for Active Living Director at Athens Community Council on Aging. So glad you've joined us today. Before we start, I want to just make a quick mention that this webinar is part of a larger series that's happening in Athens this month. We are partnering with UGA and the National Endowment for the Arts Big Read program. And the book they've selected this year is Can't We Talk About Something More Pleasant? It's a really amazing book. It's a graphic memoir by the New Yorker cartoonist Roz Chast. And it's her experience and her storytelling of her experience with her parents as they got older and at the end of their life. And I really recommend reading this. And a lot of the themes in here, aging, parenting, caregiving, how to live and age well. These have been the inspiration for our series that we have at ACCA on essential resources for adult children caring for old adults or anyone in your life. So that's the inspiration for today on legal and life planning for every stage of life. And let me just say a big warm welcome to Laura French, a great partner of ours. We're so happy to have you, and I think you're going to be able to help make the topic of legal planning more pleasant for us. That's our hope. Let me just read a little bit about Laura's background. Laura French is the founder and owner of French Law Group LLC in Watkinsville, Georgia. Recognized by her peers as a Georgia super lawyer with over 25 years of experience, Laura combines her experiences as a mom, a lawyer, and an entrepreneur to provide insightful planning to her clients. She's also a strong believer in giving back and is actively involved in the local community, serving on numerous boards, and is an adjunct professor of law at the University of Georgia. So I know you're a wonderful speaker and educator, so thank you so much for being with us.
Thank you for having me. And I want to thank the ACCA, UGA, and obviously the National Endowment for the Arts. I think this is such an important topic. Roz's book, the title of it is very relevant to what we do here in the office. And I think people have a hesitancy to talk about their mortality, the aging process, estate planning, because they just don't know and people are apprehensive. My job is to make people feel comfortable and secure and hopefully alleviate a lot of those unpleasantries. But these are hard topics, and I think it's super important that people talk about them within their families and within our community as well. So really, really do appreciate being a part of this series.
Absolutely, well said. So I'll just kind of kick things off with a very broad question that's really going to answer a lot of questions for people, especially from my age group, 40s and 50s, even 60s. There's a lot of confusion about what these terms are, like, estate planning, wills, power of attorney. They can feel a little daunting to sort of know what they are and how to plan for that. And a lot of people now are starting to realize they need to start thinking about these things. So if you could just give us a quick primer on, what's the difference between estate planning and wills, for example, or, I've heard you should have a will, not a trust, or a trust versus a will, things like that. So just start us out with that kind of 101.
Sure. So thank you. And that's a question I hear often. I think one of the most misunderstood terms is estate planning. What I do here in the office, I'm in the business of protection. I protect you, the people you love, your business, your brand, whatever it is that you have and that's important to you. And we do that through estate planning, business strategies, maybe trademark protection. But estate planning kind of covers all of those different areas. And people get confused, they get hung up, they think, oh my goodness, I don't have this particular type of asset, or I don't have this type of family, or I don't have X amount of dollars, so I don't really need to do estate planning. And for everybody who's out there, I want you to understand estate planning is all about who you are, who you love, what you have acquired and earned during your lifetime, and how we're going to fit those puzzle pieces together. And that's based on whatever your dreams are, whatever plans that I can recommend to you, so that we can secure not just assets for the next generation, for children, for grandchildren, but to make sure that you as the client are secure and protected while you're alive. And that can be through a combination of legal techniques. a lot of people say, oh, I just need a will, or I don't really need a trust, things like that. And the process of estate planning is simply figuring out, what is the family landscape? What is it, who's on the ball field and who's going to play in this estate, in this family, and how are we going to use either decision makers or family caregivers, as well as financial assets, to make sure that the individual or the couple, the child, whoever it is, gets protection. And that can mean a will, it can mean a trust. It most certainly means powers of attorney that are effective during your lifetime. And so, to kind of wrap up, maybe in a neat little bow, an answer to your question, estate planning can include any one or more of a will, a living trust, can include an asset protection trust or a house protection trust. A lot of people have questions about those. Also includes financial powers of attorney, medical directives. People use the term living will. We don't have that in Georgia. It's part of our advanced directive process. So we include both of those when we're working with our clients and doing planning. But estate planning can also include asset protection, protecting your house from creditors, looking forward, years down the road to doing veterans benefit planning or Medicaid planning. Could be planning for a special needs individual that's a child or a grandchild or somebody that you want to care for and protect. So estate planning is going to mean something very different to you than it does to me, than to, the people I've met with in the office this week. It's very unique and very tailored to each person. So I hope that's helpful to folks.
Yeah, so it's not a one size fit all. You sort of customize it to your situation in life. And estate planning sounds like it's more of like an umbrella term and lots of components within that.
Absolutely. I think that's a great description. Yes. Yeah, I think it's a great description. And, again, I believe a lot of clients that, come in the door or through the video these days are hesitant because they think, well, I don't have this or I don't have that. And I don't really know what this is going to look like for me and for my family. And my favorite thing to hear in the office is, you've answered my questions and I feel confident about what decisions I've made moving forward.
Mm-hmm. That peace of mind is so important. It's just getting in the door
Absolutely.
and having the conversation. So maybe we could dive a little deeper into, the topic is, legal planning and financial planning at life stages. So
Right.
we talked privately yesterday about this can happen over a lot of years. It's not just, in my mind, thinking when you get older and maybe have grandchildren and you need to really, think, or children. Can you just talk us through some of the phases? We can start super early or even, in our 40s and 50s for those who haven't even thought about it yet or should be.
Yeah, so I'd be happy to. And one of the hot topics right now, this time of year with estate planning, is 18-year-olds. A lot of people simply do not think about, when their child turns 18, that child is a legal adult in the state of Georgia. And that's important for two reasons. If you have a child who might be specially able, have some special needs, whether it's medical, mental health, etc., you've taken care of that child probably 24/7 for 18 years. But in the eyes of the law, that child is an adult. And so there are some probate court processes that the parents or caregivers will need to go through in order to continue that same level of care from a legal standpoint. The other issue is children, that are graduating high school, that turn 18, they may be going to college and the workforce. They are legal adults as well. And parents who are used to controlling and having access to medical decisions and bank accounts and things like that, that's lost when a child turns 18. So it's really important to have a couple of things in place when you're 18: financial power of attorney, medical power of attorney, and if you're in college, a conversation that you need to have with your parents or parents need to have with their children is the federal waiver that allows the parent to communicate either with the financial advisors and business office at colleges and universities, but also the medical and the mental health facilities that are and programs that are available on campuses. That's been a topic over the last few years that's gotten a lot of press. And, at 18, we may not think of our children as adults at 18, but legally they are. So that's kind of the first stage. We get into early adulthood, your first job, you might have a 401k, things like that. Those are times that you need to plan. When you get married, that certainly changes the equation in terms of what you may or may not want to do vis-a-vis your assets, how you want to build your life together. Children, absolutely a time that you need to plan. Parents have got to make arrangements for their children. That can be a temporary basis when parents are incapacitated. There are legal techniques that we can use to make sure that a guardian can be put in place pretty quickly to care for your children while you're recuperating. If something tragic happens and parents have died, those parents hopefully have put together a plan so that their children are physically taken care of through a guardianship, but also financially taken care of through a trustee designation. So there are a couple of different factors to think about when you're planning for children. The other thing that's important, and this goes to estate planning is not once and done. My child is 16. The plans that his dad and my husband and I have in place for him today at 16 are very, very different than what we did when he was 2 or 3 years old. And so as your life changes, as your relationships change, as you move, as you see changes in family and friends, all of those things are going to influence what your decisions are. So if folks don't hear anything except what I'm about to say, estate planning is not do it once, put it in a drawer, and never think about it. You've got to update it. As we get older, our children grow up, they become adults. Some of us are in the sandwich generation. That's where I find myself. My parents are aging. I still have a child in high school. And those are different tensions, and they need different types of attention. And so there's planning, not just that those of us in the middle of that sandwich need to do, but the parent, to sit down with your parents and have a conversation about where are your accounts, what kind of care do you want if you become, disabled, or if somebody else needs to make day-to-day medical decisions. There's the component of that decline that people can go through, and that, we see more often than versus an immediate incapacity or a sudden death. And I think there's that period of time where a person may be declining. It's kind of a gray area oftentimes in terms of determining, does the parent or the client have capacity to still make decisions or not? Where do we draw that line? And there's a lifelong continuum of making those calls. Obviously, end of life decisions are important, and that can happen to any of us at any time. We can face that situation. The important thing is that you put plans in place, you've had conversations with your family, with the people who are going to be making decisions. As we reach retirement, as we start having grandchildren, I see that my clients have very different goals in mind. There's a different level of legacy that a person can see as they get later in life. And so there may be a difference in the financial plans that an older person wants to put together for his or her family. There may be a different, grandchild or group of grandchildren that you want to benefit. For our clients that don't have lineal descendants, they've got the opportunity to not only help other family members, but to do things for their community, for charities or churches that are important to them, as everybody would. Again, estate planning is not once and done. One of the biggest things as we get older, when you're around age, I would say 65, retirement age 65 to 70, it's really important to consider house protection or asset protection. That has to do with some laws that are in place, getting past some timelines and deadlines. And I'm not telling everybody out there that you have to do an asset protection type of trust, I would encourage everybody to consider it as you get older, or if there is a known medical issue. And the reason I say that is a lot of times people misunderstand incapacity. And all and Alan, I'm sure you've seen this. I'm sure some of our participants today have experienced this. When people have a cognitive decline, oftentimes their physical abilities stay intact. And I think when family members and caregivers see that the physical day-to-day activities of daily life are able to be accomplished by their loved one, they don't necessarily truly recognize the mental capacity decline or the cognitive decline. And folks get that very confused. I'll have people come in the office bringing their parent to sign a power of attorney or sign a new will, and physically they look fine. But when you sit down and talk to the person, they're not mentally capable of signing those documents, which throws us into a completely different scenario where control has been taken away from the family because delays have occurred and the planning hasn't been done. So, from 18 on to, the time we pass away, there are lots of opportunities to create a plan, to update a plan, to secure what is important to you. And of course, our beliefs and our values evolve. And I would encourage folks to really consider at different stages in life, take a second look and see what's important to you and how you want to plan around that. So I hope that helps and answers the question.
Yeah, I mean, it is a really important message, that because when I think of, my, stock portfolio or investing in the market, it's a little bit like do it and forget it for a while. You don't take the same strategy with this. It's a living, evolving thing like we are. So that's a really great message. And to your point, also, it's a bit of a cautionary tale of you don't want to wait till it's too late. I mean, trying to set yourself up for that success earlier rather than later can benefit your family, all members of your family, because otherwise it gets put into the hands of the state and then they determine your future, and that's, no one really wants to be in that position. So I think,
yeah, I mean, that can happen. And, frankly, if you don't have powers of attorney in place and a situation arises where someone else has to make financial or medical decisions to protect you, that's going to end up in front of your local probate court judge. We have wonderful probate judges in the state of Georgia. They are deeply caring people. They also don't know your family. And that's kind of the rub. One of the things people ask me about a lot is, do I need to avoid probate court? And you've mentioned, at the top of our conversation, you've talked about wills versus trust. And this is kind of a good segue into that. Because will versus trust, in my head, is not necessarily the number one question. I feel like the number one question is, do you want control, or do you want the probate court to potentially have control? And let me explain what I mean by that. So I always say, to probate or not to probate, that is the question. Probate courts in Georgia, when somebody passes away, they have jurisdiction under Georgia law over assets that a person individually owns. So if I pass away and I own my house, it's just in my name, even if my will says it goes to my husband, he's got to go to probate court to get that house. Very commonly misunderstood. There are a lot of people that think, gosh, I've been married for 10 years, 20 years, 30 years. My spouse dies, everything belongs to me. That's not the case. The other thing that comes up in probate court, and that I think people just don't have the knowledge about this, is the difference between heirs and beneficiary. So heirs at law, those are the people that are going to inherit from you if you do not have, heirs at law inherit from you if you do not have a will or a trust or some sort of plan in place. Even if you do have a will and you have probate assets, again, individually owned don't have joint owners, don't have beneficiaries. If you have probate assets, your heirs at law get to play ball in the probate court. And here's what that means. You may have a beneficiary in your will that is different from your heir at law. For example, families leave loved ones out of their estate planning all the time. There may be a child or a grandchild for whatever reason that's excluded. If that person is an heir and they are excluded and you die with probate assets, that person gets to play ball in the probate court, gets to object, gets to potentially cause problems. So the distinctions between how probate works, how you can create your own private court through trust planning, the differences between heirs and beneficiaries, probate assets, non-probate assets. All of those things are really the questions people should be asking, not do I need a will or a trust? Because the answer to that question can only come once these other issues have been explored. And that's going to be dependent on what the family situation is, what the assets are. You know, it's everybody's favorite lawyer answer. It depends. Well, it does depend. And it depends on, you know, the person sitting in front of me and what the dreams and goals are and the puzzle pieces we're going to use to make those dreams happen.
And in addition to that, we talked a little bit before about having specialties in the legal profession and sort of who does someone go to for different things? I mean, it's like going to a doctor who's a generalist, but they send you to the cardiologist. How do we know which lawyer to pick?
Right.
Depending on our needs, can you shed some light?
Sure. So, I mean, I do estate planning work. I do estate planning work, corporate and business law, probate law, you know, death and all of those sorts of things that maybe aren't so pleasant to talk about. I have colleagues that are DUI attorneys, that are divorce attorneys. You're not going to come to me for a divorce. You're not going to come to me to defend your DUI, just like you're not going to go to them to get your will or trust written. It is very similar to, you may see your general practitioner on an annual or biannual basis for whatever medical tests and screenings you need, but you're not going to go see your general practitioner when you need brain surgery. And that's kind of the analogy that I think people should keep in mind. There are a lot of tremendous general practitioner lawyers in the state of Georgia. There are people that are really good at being jacks of all trades or Jills of all trades. But I think when you're talking about, you know, your life, your finances, your assets, the people that you love, the people that you would step in front of a train for, I would encourage people not to leave that up to somebody who doesn't do this type of work every day for years and years. You know, it's a friend in the law, and I always say, we cannot unsee the things that we've seen come across our desks. And it does take, you know, that day in, day out training and learning and just the experience of working with individuals and families to identify issues. And, you know, just like I might be able to spot, oh, you need this type of criminal defense attorney, I'm going to refer that out because I'm not the person equipped to do it. So I would just, you know, do your research, you know, find somebody who is practicing in the area of law that you really need help in.
Yeah, that's a fair point. And to add to that too, there's always been in my mind a subset of elder law. I hear that term a lot. Obviously, I work at a senior center that is thrown around, but I don't quite know the difference of what, is that a special area? Can you talk a little bit about what elder law means versus?
Yeah, so you talked about estate planning and that term being an umbrella, and that's exactly right. So within estate planning practices, there are a couple of different components. Special needs planning is one of those. Elder law planning is another. Elder law planning really brings in a couple of different legal techniques. You know, we've talked about asset protection, house protection trust, planning for public benefits that you may be entitled to. That can either be through the Veterans Administration It can also be Medicaid. If you have a child under 18, it can be Katie Beckett. There are lots of different public benefits programs within special needs and elder law that, frankly, people just are not aware of. But the elder law component, in the way I approach it, in the way I think about it and work with clients, it's really those conversations around, what happens when you can't do something? Or let's talk about maybe you can still do things for yourself, but you just don't want to. You've gotten older, you don't feel like, dealing with the bank on a day-to-day basis. You don't necessarily want to have to manage your brokerage account, on a monthly basis or weekly basis, whatever it is that you've been doing all these years. And so there's stages within that aging process where I have found that people like to start turning over some of the day-to-day decisions. I also think it makes it easier to grow into a potential sudden situation. If you've got your children or your, adult grandchildren or other trusted people within your life who are aware of what your wishes are, it's going to make things easier when the time comes to make decisions. The elder law component can also involve second marriages. I've got folks that we work with that get married much later in life, get remarried much later in life. People lose a spouse or they get divorced and they don't get remarried maybe until they're in their 50s, 60s, or 70s. And that's another type of elder law planning, because you've got potentially, I hate to use the word competing interests, but you've kind of got two families in play with one person in common to those two families. And so that's an area of elder law planning. Is it going to be the new spouse that takes care of these things? Is it going to be an adult child? Combination? How are we going to divide these responsibilities up? So the elder law component really does bring in taking a look at long-term care. How is that going to be paid for? Are you eligible for public benefits? Do we need to do asset protection planning? When do we need to do asset protection planning? And who do you want to care for you? And that's financial care and decision making, as well as medical care and healthcare decision making. So I hope that helps. It's a subset. It's very related, but to sort of general estate planning. But there are some very unique and very specific conversations that need to occur when there's an illness, a diagnosis, or just through the normal aging process.
Okay. So if someone like me, for example, has two parents, 70s and 80s, and doing great, but in my mental checklist of what conversation should we be having, what's on that list? Some of the things you mentioned probably, but where should our head be when it comes to,
right.
We still have time, but we want to be prepared, and I want to make sure everything's in order and help them.
Sure.
They're reluctant in some way, but
yes.
What should be on my brain?
Yeah, so I think it's really important that, you or somebody in your shoes is, and you know how to do this because of what you do every day in the Council on Aging. But it's important to be respectful. It's important to be gentle and to not try to take away power and agency from the aging loved one. It's, you can't, you can lead a horse to water, but you can't make them drink. And a lot of the conversations I think need to be around, okay, I want to make sure I can care for you, that I'm legally able to do it. Would you be willing to have a conversation with an estate planning attorney? Mm-hmm. And it doesn't necessarily mean that you come to the meeting, that's a different conversation. But it's encouraging that meeting to occur. It's knowing where documents are if they have been prepared. It's understanding how old those documents may be that mom and dad put in the drawer. A lot of people plan at two phases of life: when they have kids, right before they go on a trip, and when they retire. But there's other planning, as we've said, that needs to happen in between and also well after retirement. Making sure documents are updated. Georgia law changes. Our powers of attorney have changed actually twice in the last several years. So there's certain powers, especially within the financial power of attorney, that need to be specifically discussed when we're talking about elder law issues and aging issues, to make sure that the client, that your parents, for example, understand what they may be granting the power for you to do, and that they're comfortable with that. It's their decision. From a medical standpoint, there are conversations around end of life. There are conversations around palliative care, hospice care, refusal of care. People that have had multiple bouts with cancer oftentimes will say, I'm just not going to do this again. I'm at peace, and that's hard for family members to hear sometimes, but there's planning around that can take place. Medical directives are super important. One of the most important documents, and this is more of a personal comment, because we've had some medical challenges in our family recently, we prepare a health privacy document. And having that document has made it very smooth in terms of communicating with medical providers. The healthcare directive, coupled with the health privacy directive and authorization, can really make things smooth for a family, because there's nothing worse than calling a doctor's office and being told, we can't talk to you, when you're the person who's the decision maker. And so there are tips that that people need to know to make sure that happens. Aging of documents is something that can really create a problem. Not knowing where documents are. If you can't find the documents, they're not any good. If they've been written on, they might not be any good. They're just different things that we see pop up here in the office that have to be addressed. Another component in working with aging loved ones is understanding the financials. What do you have? What are you entitled to? Do you have a pension, life insurance? Where are your investments? Who's your broker? Who do you want to have your things? How do you want things split? How do you own your assets? Who are your beneficiaries? And so it doesn't necessarily mean that the adult child or the adult caregiver has to take over all of this material, but I think there needs to be a conversation within the family about how these things are going to work. Mm-hmm. And when decisions have to be made, who's going to make them, and how do you get to the bank account to pay for something that needs to be addressed? Where do you want to live as you get older? When it's time to move out of your home, where are you going to go, and what do you want that to look like? Again, back to the title of the book we're all working with. It's not pleasant. These are awkward. These are uncomfortable conversations, but they're necessary and they're important. And I also have seen and absolutely believe that in having these conversations, if both the aging person and the other loved ones are willing and able, it can really lead to some closer connections and closer relationships, learning things about your parents or grandparents, aunts and uncles that maybe you've never heard. And I would encourage people to do it. It's hard, but I think you would rather it be hard than miss the opportunity to do it.
That's a really interesting point. There's a silver lining to that conversation, that
there is.
You learn about your loved one more and feel more connected and bonded, and just having that peace of mind as you go forward that you'll make the right decisions because you know what your loved one wants. And there's nothing better than that, because it gets stressful towards the end of life and death. And, you want to have your children feel like they have some security and confidence when they're making decisions,
Right.
or when you're unable to speak for yourself. But I really like how you talk about approaching these conversations with sort of care and gentleness. I
Mhm.
think it's very easy for us to sort of say, well, you need to do this. And I know what's best. We become the parents, right? We're like, we know what's best now for you. But that's not true. And it's a team effort, it's a family effort, and it's a mutual.
Yeah, and it's hard, and nobody's perfect at doing it. I'm certainly not perfect at doing it.
Yeah.
I don't expect anybody to be, but it's important, and I think that one of the most important gifts that a parent can give to a child who is going to be put in the decision-making role is to know what you want done. Um, both of my parents are still living. I've not had to make any of those, very difficult decisions. I have had to do it for someone else. And when the time came and the doctor said, here's the DNR, here are the papers, here's the removal of life support, he said, you don't have to sign this. And I stood there for a second, kind of took my breath and said, she counted on me to sign this. And she counted on me to do this.
Wow.
And I'm going to do it. And it didn't make it easy. But I was confident in what I was doing.
It's
And,
powerful.
and that's the gift.
Mm.
That's the gift to your family, because you've removed any of that second guessing, any of that worry. I think it's a gift.
Very powerful. That reminds me of another question I had about what if you don't have children? What if you're going through life and great life, but those beneficiaries may not be there. But you want to maybe consider, your assets going to your parents,
Right.
or charity, or another relative or something. Like, how do you think about that scenario?
So I actually love the opportunity when I have people that come to me that don't have children, whether they're single or married, because the planning is removed from what you're expected to do. There's not oh, well, it goes to the kids and the grandkids. I think it allows those clients to kind of think outside the box a little bit more. Obviously, I try to get all of my clients to do that and think about different ways of thinking of and looking at their legacy and planning for it. But when you don't have children, oftentimes I've found that, first of all, there can be a lot more wealth because you haven't spent it on raising, one or more children. But there also can be different interests, different hobbies that were pursued, different collections, different life experiences. And so those are things, that all of us have. But I have seen, there's several clients that are putting a smile to my face that are kind of popping to mind over the years, where they've had something pretty unique to leave. Not necessarily in terms of stuff, but in terms of life experiences. And I think that's the most important thing to leave. Lots of clients that don't have children do want to take care of their parents. That can throw us back into elder law planning, because we don't want to do something. And this is true with special needs children or other beneficiaries, as well as elder law beneficiaries, or elder beneficiaries. We don't want assets going to somebody in a way that may throw them off Medicaid, that may take a public benefit away. And so there are ways to protect that. And when I have people say, oh, well, I want everything to go to mom and dad, there's a secondary conversation. Well, let's talk about mom and dad. What are their needs, and how can we best plan for that? You can set up trusts for parents. You can set up trusts for other adult family members. People have done scholarships. People provide things to, whatever cause has been important to them. You can take care of friends. There's been something in the news recently where George Clooney delivered $1 million to his 15 best friends or something, when he first hit it big. Think outside the box. There are lots of wonderful opportunities to really potentially change somebody's life who you're not expected to do it, and they certainly are not expecting it from you. So, again, you're sort of free of those typical, what you have to do restraints, or what you should do. I think everybody should feel free of those. But, of course, the reality is when we've got children, or grandchildren, we're going to want to take care of them. But don't think that just because you're single or you're married and you don't have kids, that you don't have something to plan for, because there are tremendous opportunities to talk about that and make something happen that's important.
I love that. That creative planning is
Yes,
great.
absolutely.
Well, thank you for that. So we do have some time left for questions. I
Okay.
want to turn it over to any of the attendees. I would ask you to raise your hand. So, or you could unmute yourself. I'm not still learning how this works. There should be something you select that says raise hands at the bottom of your screen, and I'll be able to see that, and then I can unmute you. So does anyone have any questions for Laura?
And I think people can probably either do Q&A or chat, and then we can
That's true. If
chat.
you want to type something in and send it to us that way, that works as well. Okay, I see Vivian. Let's see. Vivian, can you hear us? Oh, your microphone is still muted. Let's see. Are you able to unmute? Here, let's see. Disable talking. We can't hear you. Are you? Did something pop up that said host is asking you to unmute? You would just click that. It won't let me do that for you unless I try one other thing. Should allow you to unmute. Here, no. I think you're talking, but we can't hear you. Maybe you could put it in the chat box. Do you see at the bottom the little word bubble, or the Q&A? Try that as well. Strange, that's not working. I see you on the screen.
Yeah, and Vivian, if you're on a phone, sometimes that's harder to sort out the unmute button. But there should be something there that hopefully will help. But if not, feel free to type it in the chat, and I'll be happy to take a look. While Vivian's sorting that out, I want to mention a couple of. I'm just going to say these are mistakes. These are common mistakes that I see people making. Number one, do not simply go into the bank and add your children or grandchildren to your bank account. Same thing is true with your real estate. Don't just think I'm going to put my child on the deed and that takes care of it. You are doing inadvertent estate planning by doing that, and the consequences of that are oftentimes not at all what people expect them to be. One of the things I hear very often is, oh, well, I've left my $1 million life insurance policy or $100,000 life insurance policy to one person because I know that person is going to pay my bills and then split it with his or her siblings. Sometimes that happens. A lot of times it doesn't. And I can't legally enforce those wishes. So don't do inadvertent estate planning by adding people to accounts or improperly naming beneficiaries in a way that is not going to accomplish your goals. So that's one of those are a couple of big things that I see. The other things that I would also mention is really pay attention to when your powers of attorney are effective. So this is something that can come up often and also change during your lifetime. Powers of attorney can be effective as soon as you sign them, or they can be effective upon incapacity. There are reasons as we get older that we may want to change a power of attorney to be effective immediately. That goes back to, you want your child to be able to run to the bank. You want your child to be able to deal with your health insurance company or pay your bills online. Having an effective power of attorney, as a current immediate date can facilitate that. The downside is obviously it's effective immediately. It doesn't mean your child has to do everything. It means your child can, or that your agent can. Agent may not be your child, but those are some things that do need to be addressed and reviewed as time marches on. If you're diagnosed with an illness, if there is a decline in mental health or medical status, you may want somebody to help you make medical decisions. And that's a different conversation than the financial one. But periods of decline and end of life are two very different areas. And I would encourage folks to revisit those during phases of life. So I see that Becky has a question. What is a beneficiary and how is that different from a legal heir? So I'm going to answer that question, Becky, in with a couple of examples. So legal heir in Georgia is the person or the people that would inherit from you if you die without a will. Georgia has written a will for every single one of us. It may or may not, and most likely does not, say what you or I would want it to say. I am married, we have one child. If I pass away without a will, most people probably assume everything goes to my husband per Georgia law. That is not correct. It would be split equally between my husband and my son. That example can become really important and really complicated if you're in a second marriage and have his and her children. Because if you're in a second marriage and you have a stepchild and your spouse dies, you and the stepchild are the heirs. A beneficiary is the person that you have designated on an account. For example, an IRA has beneficiaries. You'll hear the term beneficiary, pay on death, POD, or transfer on death, TOD. Those things all legally have the same effect. It's a beneficiary designation where you are saying, I want this IRA account, I want this life insurance policy, I want for my CD to go to X person. That's your beneficiary. Your beneficiary also can be the people you name in a will or a trust. Back to the will situation, if you have a beneficiary who is different from your heir at law and you go to probate court, it puts the beneficiary and the heir who may not be included in a potential conflict situation. So I hope that answers your question.
That's interesting. Let's see, Vivian, I'm sorry, we can't still hear you.
Oh, Vivian's unmuted.
Oh, hey.
Can you hear me?
Yes.
Okay. I recently had power of attorney done for my husband. He has an illness, and I had that done in 2020. Has the law changed since then?
The law has not. The law was updated 2 years in a row, and it was 17 and 18 or 18 and 19. I always have to go back and look. The legislature changed it, and then a state planning attorney said, hang on a second, we don't like some of the stuff that's in here. I don't know where you had your powers of attorney done. The important thing is that you have the current Georgia documentation, because the changes that did take place a few years ago included some things that have added benefit and protection for the principal, who's the person making the power of attorney, but also for also benefits for the agent, the person carrying out the wishes and acting as the power of attorney, that make it a little bit easier to maneuver things. So
what are the benefit protections that are provided?
I'm sorry, can you say that again?
What are the benefit protections that are provided?
So the Georgia Power of Attorney is divided into two sections. There is a general section and there is a specific authority section. The general section is what most people, I would say, associate a financial power of attorney with. Dealing with your bank accounts, paying your bills, selling real estate, all of those sorts of more day-to-day common things. The specific powers are enhanced powers. They are very broad and they need to be specifically addressed with a legal professional before the principal initials any of those. They are, in my view, they are very powerful. They are extremely broad and can lead to some unintended consequences if the people signing and operating under that document don't truly understand, what those powers are. So,
Okay.
one of the protections and benefits is if you have the current Georgia power of attorney and it's executed in accordance with Georgia law and everything's, properly signed, the person who signed it was competent to do so, then third parties have to accept it. If they don't, you can file suit to enforce that. So we used to have a lot of problems where third-party financial institutions did not want to accept powers of attorney. They just made up their own rules based on whatever they felt like was important, or their legal department felt like was important. But now they have to take those. If they don't, there's a legal process you can pursue to enforce that.
We obtained this because he had to have a lot of medical treatment.
Yes, ma'am.
And he's still under treatment. And the facility that we attended and was in would not even take my power of attorney papers. They said that wasn't necessary, and they never took those, but I helped make decisions, and I thought that was very odd. I wanted to know how long is the power of attorney valid? And can the person who's giving you that right, can they independently make decisions about things themselves? I don't know how that works. It's confusing to me.
Okay, so powers of attorney are valid during a lifetime. They are not valid when somebody passes away. This is something I hear very often. People will call and say, Mom or Dad has died. I've got the power of attorney and I'm going to the bank to close the account. Well, you don't have power of attorney anymore because the power of attorney dies when the person dies. So that's kind of, the first thing. There are powers of attorney that expire, and there can be a specific date included in a power of attorney if that's something that's important to the principal, the person signing it. A financial power of attorney may not have been required or necessary with the medical providers, but a healthcare directive may have been important. So it really just depends on the type of things that you needed to do to help your husband. To answer your question about can your husband do things and can you do things, it depends on what that power of attorney says. If it says it's effective immediately, then it's very likely that both of you can act. But without seeing it, I can't give any sort of specific legal advice on that.
Okay, thank you very much.
You're welcome.
Thanks for your question, Vivian. It just really shows you how broad everything is and how nuanced. There are just so many questions. We have a couple of minutes. Is there one more quick question that anyone has to get in before we wrap up?
So Melissa's typed one in, and this is a fair question. It's also a little bit of a tricky question, and I'll explain why. So Melissa's question is, it seems like there are not a lot of benefits over choosing a will versus a trust. If I understand what you're saying, is there ever a situation where a will would be more optimal? Honestly, I can't think of one off the top of my head where a will is preferable to a trust. And the reason I say that is because I want my clients to have control and power and agency over not just their lives and the decisions that are going to happen while they're alive, but also what happens after they're gone, so that it's easier for their family members. I like to think about estate planning in two phases. There's the planning that is important while, I'll just use a couple, for example, while a married couple is alive, capacity, don't have capacity, whatever the situation is, but there's that group of planning for a lifetime. Then there's the planning about what happened, what's going to happen when somebody dies. And if you want control, you don't get control with a will. I mean, it's just that simple. There are situations where between a husband and wife, it can be straightforward in terms of avoiding probate and avoiding and preventing some of the complications that I've mentioned. That's great if it's just between the couple. But when the second spouse passes away, there's a secondary level of probate that takes place. And while we may be able to accomplish that first set of goals between a married couple at the first death, I can't guarantee that in a will when the second person dies. Another issue that can come up is making sure that everything is titled and that the powers of attorney are updated, all of those things, because somebody can die and the spouse is incapacitated. And you've got to have somebody who can act on behalf of that incapacitated spouse or other beneficiary. I love trust planning. I'm kind of a trust nerd. Having said that, I do not believe everybody needs one. I think there are situations where it's critically important. Minor children, special needs beneficiaries, incapacitated beneficiaries, blended marriages, assets outside of the state of Georgia, real property assets. And all of the reasons behind those things have to entirely do with probate. Again, the question is, do you want your own private court that you've built? It's your ball field. It's your rules of the game. It's who gets to play. You pick the players, you pick the referees, you pick the rules. Or do you want Georgia law to dictate what's going to happen? My feeling is most people want to build their own football field or their baseball field or soccer field, whatever it is, so that their family's taken care of. So, Melissa, I hope that has answered your question. Thank you for sharing that with us.
Thanks, Melissa. And that's our time. It's been an hour and it's been jam-packed with good information. And thank you so much, Laura, for your time and expertise. There's so many more questions we could ask. We could really go on all day. But I think you've helped frame it for us really nicely. I think my takeaways are legal planning is not a one-time event. It's not a one-size-fits-all. So it changes throughout your life and to whatever your needs and wishes are. That legal planning is a gift to your family. I love the way you frame that. That's beautiful. And to start taking steps to have those uncomfortable conversations. And if you're an adult child talking to a parent, do that with some love and care. And if you're the parent, what do you want? You're in charge, and do this while you still can with your family and set them up for success and yourself as well. So those are my high level takeaways, but thank you again so much. And thank you all attendees for joining.
You are so welcome. Again, thank you. And the ACCA, UGA, and the NEA for having me today. It's been an honor. If I can answer any more questions, feel free to reach out. My email is laura@frenchlawgroup.com. If I can help anybody, I'd love to do so. Thank you so much.
Thank you so much. Take care.